I need you to stop scrolling right now because what I'm about to show you is not hyperbole and it's not another premature prediction. At 3:47 p.m. Eastern Time today in Courtroom 4B of the E. Barrett Prettyman Federal Courthouse in Washington, D.C., something happened that has no modern precedent in American politics. A federal judge issued a criminal contempt citation against a former president of the United States after his entire lead legal team walked out of court, gathered their briefcases, and abandoned him mid-trial. Within 6 hours of that moment, over $200 million in committed campaign donations evaporated. Three of the Republican Party's most powerful financiers publicly cut ties with Donald Trump. And tonight, senior officials at the Republican National Committee are privately discussing scenarios where Trump is no longer the presumptive 2028 nominee. This is not partisan spin. This is not media speculation. These are documented facts, on-the-record statements, and verified financial disclosures that together paint a picture of political collapse happening in real time. What you are about to understand is not just what happened in that courtroom today, but why it happened. What it reveals about the fractures that have been building for months, and what it means for the future of the Republican Party and the 2028 presidential race. By the end of this video, you will have a clearer picture of where this is heading than most people in Washington do right now. Let me reconstruct precisely what unfolded in Courtroom 4B of the E. Barrett Prettyman Federal Courthouse today. Court records show proceedings began at 9:47 a.m. Eastern Time, Judge Tanya Chutkan presiding, Trump's lead attorney John Lauro presenting arguments on a motion to dismiss charges in the federal January 6th case. For the first 20 minutes, routine proceedings. Then the atmosphere shifted. According to pool reporters from CNN, The New York Times, and The Washington Post present in the courtroom, Judge Chutkan began interrupting Lauro with increasing frequency, challenging his characterizations of prior rulings and evidence. At 10:25 a.m., the decisive moment, Judge Chutkan asked Lauro directly whether he had personally reviewed the prosecution's evidence files submitted the previous week. Lauro hesitated. The judge asked again. Lauro admitted he had not personally reviewed all materials but had received summaries from his team. The official court transcript records Judge Chutkan's response verbatim. Counsel, you are arguing about documents you haven't read. You are making representations to this court based on secondhand summaries. That is not advocacy. That is malpractice. She announced consideration of sanctions against Trump's entire legal team. She gave them until 2 p.m. to produce documents under subpoena for 3 weeks, then recess. At 2 p.m., when court reconvened, John Lauro stood and announced that he and 2 colleagues were withdrawing from the case, effective immediately. His stated reason: irreconcilable differences with the client regarding legal strategy and ethical concerns about representations being made to the court. Then he walked out. 2 attorneys followed. The remaining defense presents, a junior associate and a paralegal, neither qualified to represent a former president in federal criminal court. At 3:47 p.m., Judge Chutkan issued a show cause order requiring Trump to explain within 48 hours why he should not be held in criminal contempt. She issued a bench warrant requiring his personal appearance Monday morning. And she made clear that if attorneys abandoned the case over concerns about false representations to the court, she would investigate thoroughly. To understand why today's events are truly unprecedented, consider the closest historical parallel. October 1973, the Saturday Night Massacre, when Nixon's Attorney General and Deputy Attorney General resigned rather than fire the Watergate special prosecutor. That was government officials refusing an order they considered unlawful. Today is different. Private attorneys withdrew from representing a client because they apparently believed he was asking them to make false representations to a federal court. Under Rule 1.16 of the Model Rules of Professional Conduct, attorneys must withdraw if continuing would require assisting criminal or fraudulent conduct. Lauro's explicit reference to ethical concerns about representations signals precisely this. This pattern connects to a structural reality. A 2022 Law 360 survey found that of the top 100 white-collar criminal defense attorneys in America, 0 were willing to represent Trump in federal matters. Cited reasons: reputational risk, client unwillingness to follow legal advice, payment concerns. Today's public courtroom drama will only deepen that reluctance, making Trump's search for replacement counsel extraordinarily difficult. The legal implications are immediate and severe. Trump faces a 48-hour deadline to respond to Judge Chutkan's show cause order. Criminal contempt under 18 U.S.C. Section 401 carries potential daily fines, court-ordered compliance directives, or in extreme cases, incarceration until compliance. A contempt finding could also be introduced as evidence at trial, supporting prosecution arguments of obstruction patterns. The representation crisis is equally acute. Federal criminal trials at this level require experienced attorneys with security clearances, classified information expertise, and federal procedure mastery. Building such a team normally takes months. Trump has days. Judge Chutkan's options if he fails: appoint counsel, stripping Trump of defense control, delay the trial, which he has consistently resisted, or proceed with inadequate representation, risking conviction but creating appeal grounds. Monday morning's required court appearance is the immediate flashpoint. The political collapse moved faster than the legal developments. Within 3 hours of the courtroom walkout, 3 pillars of Republican megadonor infrastructure issued public statements. Kenneth Griffin, Citadel founder, $15 million to Trump super PACs in 2024. A disgrace to the legal profession and an embarrassment to the Republican Party. Immediate cessation of all Trump-aligned financial support. Stephen Schwarzman, Blackstone CEO, confirmed to the Wall Street Journal, Bloomberg, and CNBC $100 million redirected away from Trump's Save America PAC to other Republican candidates. $100 million is not symbolic. It is strategic repositioning by someone with information and relationships most observers lack. Miriam Adelson, widow of Sheldon Adelson, through her family foundation. All political contributions suspended pending review of the 2028 field. Combined over $200 million in committed or expected donations now gone. But the number understates the impact. In Republican donor networks, Griffin, Schwarzman, and Adelson function as permission structures. When they move, others follow. Fundraising consultants report a Dallas event postponed indefinitely, 2 February events canceled, major bundlers unable to secure commitments for Trump events. The money infrastructure is collapsing in real time. Republican elected officials are reading the same signals. Senator John Cornyn of Texas, concerned about courtroom developments, believes all candidates should comply with legal processes. Senator Lindsey Graham asked about 2028 support. I support whoever the Republican nominee is, but I think we need to focus on winning elections, not fighting legal battles. Mike Pence. What happened in that courtroom today is not the leadership America needs. These statements represent significant departures from previous lockstep loyalty. Senior RNC officials, according to Politico, Axios, and the New York Times, are actively discussing scenarios where Trump is no longer the presumptive nominee. The polling data compounds the crisis. A Quinnipiac poll released tonight shows Trump's Republican primary support at 39%, down from 47% 2 weeks ago. 8 points in 2 weeks. DeSantis has risen to 34%, closing the gap to 5 points. A University of New Hampshire poll shows DeSantis leading Trump 38-36, the first time DeSantis has led in any early primary state. Demographic breakdowns are particularly revealing. Trump's support among Republicans under 45 dropped 12 points, among college-educated Republicans 15 points, among self-identified moderates below 30%. When asked why they are reconsidering support, Republican voters cite legal troubles, electability concerns, and fatigue with drama, not policy disagreements, fundamental viability questions. Meanwhile, DeSantis' super PAC announced $23 million raised in 72 hours. Record-breaking pace. International observers are watching closely. European allies, already wary of potential Trump return, are assessing whether American institutions can constrain a figure who repeatedly challenges legal norms. Authoritarian adversaries are watching for dysfunction evidence useful for domestic propaganda. Russian state media is already framing today as political persecution, mirroring Trump's own messaging. The key players reveal the dynamics at work. Judge Tanya Chutkan, Obama appointee, former federal public defender, known for strict procedural adherence and tough January 6th sentencing. John Laurow's decision to withdraw publicly, citing ethics, represents either principled stand, reputational protection, or both. Knowingly making false court representations risks disbarment. The donor decisions reflect different calculations. Griffin was already seeking alternatives since 2022. Schwarzman's move signals fundamental reassessment. The Adelson pause suggests watching and waiting, notably silent. Trump himself. No formal statement beyond campaign spokesperson's release. Truth social quiet since morning. Uncharacteristic silence suggesting either crisis management or genuine uncertainty. The next 48 hours are critical. Trump must file his show cause response and identify replacement counsel. Monday brings required court appearance. Over 1 to 4 weeks, watch for additional donor defections, polling trajectory, and DeSantis strategic adjustments. He is scheduled for 3 days in Iowa next week. Nikki Haley and Tim Scott are reportedly testing donor waters. Over 1 to 6 months, the primary calendar takes shape. If Trump cannot stabilize, he could finish second or third in early states, effectively ending his campaign without formal withdrawal. The historical record suggests caution in predicting Trump's demise. He has survived scandals that would end other careers. But today's crisis differs fundamentally because defections come from inside. Not Democrats attacking, not media criticism, his own lawyers walking away, his own donors cutting off, his own party preparing alternatives. One wildcard scenario: Trump refuses Monday court appearance. Daring enforcement of the bench warrant. Constitutional crisis of the first order. Here's what we know for certain. Trump's legal team abandoned him in open court over ethical concerns. A federal judge cited him for potential criminal contempt. Over $200 million in donor commitments evaporated in 6 hours. Polls show his closest rival within 5 points. Republican leaders are preparing for alternatives they would not discuss a week ago. What makes today different is the source of damage, not external attack, internal collapse. When your own attorneys cite ethics concerns, when your own megadonors publicly redirect hundreds of millions, when your own party creates rhetorical distance, something fundamental has shifted. I am clear about what I do not know. I do not know exactly what happened during the lunch recess. I do not know whether Laurow's concerns will be substantiated. I do not know if Trump can find replacement counsel. What I know is that today changed the 2028 trajectory in ways that cannot be undone. The facts are in the public record, the statements have been issued, the calculations have shifted. Subscribe and turn on notifications. Decisions are being made right now that will shape the next election. You do not want to miss what comes next.